when it comes to Northwestern Mutual disability denials, there's a couple options that people have, because a lot of times people get this denial letter, and if it's an individual disability claim, it will say, we've denied your claim. You have maybe they give them the right to appeal internally to the company, but probably not required by the policy. If it's a group policy, they are required to appeal. And if not, Northwestern basically says, you've been denied, here's the Department of Insurance information, or you have the right to now seek further remedies, which would be a lawsuit. So I want to touch on now talking about how we help people, whether they're doing an appeal or a lawsuit. And if it's ERISA, which is a group covered policy, then we have to do an appeal. If it's not ERISA, very often we still want to do an appeal because we want to continue to build up the evidence to make it look better before we file a lawsuit. But in some situations we may say, you know what, if we have the opportunity, we're just going to go right to a lawsuit. Now, a lot of lawyers can be overly aggressive and be like, yeah, we're going to sue, we're going to get in there right away, but that may not be in the best interests of a claimant, because at the end of the day, 98% of these cases end up resolving in some kind of settlement without going to a trial. And we understand from doing this so long, the clients are in a situation where they don't have income coming in. The quicker we can get this resolved, the quicker path they have to getting money coming in again. So really, if you can avoid someone litigating for 2-3 years before they're possibly going to see money, and maybe they don't even see money because they lose, you always want to look for what I call that path of least resistance. How can we reach a resolution? We've been doing this long enough now to have dealt with Northwestern Mutual probably more than any other disability law firm in the country, where we can get them to say, let's try to work this case out, because we know you can litigate with us for 2 years. You know you can make us spend a lot of money. We know your client's going to have to spend a lot of money. But I do believe, to kind of throw Northwestern a bone, while they may deny a claim, they're still one of the few companies who will have some sort of reasonableness to try to do what they can to reach a resolution. They realize what's going on, about the business side mechanics of what it's going to take to go through a case. So, but it all starts with, first you got to put an appeal in, or you got to do a lawsuit. So let's talk about how we help someone to do an appeal and why it's so important to have a super strong appeal.
Yeah. Well, sure. You have, in certain cases, you mentioned an ERISA group policy. So in those instances, those appeals are mandatory.
Right.
Okay. And the first steps you take, and I try to take them both on the ERISA cases and in the individual cases, is request the claim file. Now, in the individual cases, they don't always have to give you the whole file, meaning their internal notes and memos and physician records and reviews and things like that. They don't have to give you that on the individual side. And someone may ask, well, why not? Well, it's just being on the ERISA side. There's a federal law. There's rules, there's requirements that they have to provide that information under federal law. On the individual side, it's all governed under state law, so those same requirements aren't in place. And they're not going to give you necessarily anything that they're not required to give you. Okay, so you may have to bring a lawsuit, you may have to subpoena documents and records to really get the entire file eventually. But those files are really helpful if you're going to put together a meaningful appeal also. So that's one thing I always try to point out to Northwestern Mutual. When I reach out to them and I ask for their files, I say, you've invited this appeal or this reconsideration, but how are we supposed to do it?
Absolutely.
If we don't have, how are we going to submit a meaningful appeal, and how is our client going to receive a full and fair review if we haven't even seen what you have, the full extent of everything you've considered to say they're not eligible or to deny their claim. So that's one of the first things we ask for. And the next thing, in reviewing those files and reviewing all our clients' records, and those take time to put together and bring in and comprehensively go through everything meticulously, and then determine, well, was there some place here, was there a vulnerability here that they, I guess for lack of a better word, exploited or took advantage of to deny it? Our client is struggling with cognitive impairments or cognitive symptoms, but there's no neuropsychological exam that's been done. So that's possibly something we should do or send our client to. They've got these complaints about their physical pain and limitations, physical limitations, but there's no real extensive physical or functional examination or evaluation that's been done. So we may consider doing that. Their doctors really haven't expressed or communicated what kind of limitations are claimants presenting when they go to their doctor's visits. The medical records may be kind of very brief or vague. So we may want their own doctors to complete a comprehensive, very specific attending physician form or statement or letter. So those are the types of things we need to coordinate and put together to really get a meaningful appeal in, and for our client to receive as close to a full and fair review as we could possibly get with Northwestern Mutual.
So when I tell claimants about these appeals, again, ERISA or individual, I tell them, look, we're looking at the appeal and we want to win at this appeal level, but this is like a journey down the road on a trip that we've been on 50 times, and we're going to take you on this trip now for the first time. So we already know everywhere we're going, and we're going to plan out the whole route, and we know all the highlights that we're going to take you to see. But we are always thinking about the end result is that this is going to either be reviewed by a judge or a jury. So as we're going through this appeal, everything has to be very calculated in a matter of not just how's Northwestern Mutual going to look at it, but how are we going to give them information that hopefully no one at Northwestern Mutual could reject. But more importantly, how could a judge or a jury look at this and say, how could you say this person could go back to doing their work? Or how could you say this person isn't disabled from performing any job? And so what that means is that a lot of it comes down to the facts. And when you're already somebody who's a claimant who's disabled and knows they can't do their job, you're sitting there basically saying, what else can I possibly do to prove to you? Why don't you just believe me? I'm telling you I can't do this. But there's more than just the words of the claimant, and that's where we get into the appeals and dig really deep and look for tons and tons, not look, provide tons and tons of additional information, whether that's through, and you touched on some of them, whether it's getting additional medical doctors to examine and treat the claimant, whether it's bringing in outside experts for whether it's physical therapists for functional capacity or psychologists for neuropsychologists, whether it's a doctor at one of the top teaching hospitals in the country to do an evaluation, whether it's our own independent medical examination that's done of the claimant, whether it's doing extensive medical research on the particular medical condition to say, oh, absolutely, somebody who has a cardiac issue can't be returned back to the work environment because stress is going to aggravate their cardiac condition. And here's literature from Harvard, MIT, Northwestern, WashU, all of these top hospitals around and teaching institutions around the country. And you have to follow. This is why these people did these studies. You can't put this person back in this work environment. Or here's why this particular medical condition has these symptoms. What about tons and tons of our cancer clients who luckily go back and they're what's called in remission, but they still have these cognitive symptoms. They're still fatigued from all of the treatment that they had. The literature is, I mean, it's extensive on that, yet the disability company just says, well, you're in remission, go back to work. So these are the things that we build the evidence, not just for the disability insurance company, because a percentage of the time they may ignore what we give them, but actually that could be a blessing in disguise for the person if they don't win, because now we show that they've acted unreasonably. And the jury's going to say, how did you ignore all of this information? But guess what? If you're a claimant and you don't have a lawyer or someone representing you to get all of this world of information, then you're not going to have anything if you wait to get a lawyer to litigate for you, because that information was never built. So I know you do, I do, everyone always says we win these cases in the appeals. Now the blessing, if you're not in ERISA, we can still build up all of this stuff for somebody with a Northwestern policy who has been denied but doesn't have all of this. We can get it and get it all into the court system for them. So I want to touch on the remedies, because a lot of people call you and go, Caesar, I've been denied, you know, but obviously if you win the appeal, they'll get reinstated and they'll get their benefits. But what happens if you don't win the appeal and we have to go to a lawsuit? What are the remedies and how do these cases usually resolve?
Well, the remedies, particularly in individual cases, it depends on where the claimant lives, where they reside, where the policy was issued, where it was delivered, because the remedies depend on where the cause of action is brought and under what law it's basically governed under. every state has different remedies. But to begin, most of them, almost every single one of them, will have breach of contract remedies. So recovery of the benefits that you're owed, because that's what you're seeking. You're seeking to enforce the terms of this agreement, and if you prove your case, the jury's going to award you what you're owed under the policy. There are some state laws that provide for bad faith remedies, meaning that the insurance company, Northwestern Mutual, has acted in such an egregious manner, okay, in such an unconscionable manner, and that's all factual, really, that you're warranted, or it's warranted here to pay you these bad faith benefit or damages, and those damages are usually predetermined in terms of how it's calculated by the state law. Okay. Outside of that, there's also legal fees, attorney's fees that could potentially be recovered if you prove your case, and that's also dependent on state law. So those are generally the remedies, right? But what happens after that? Because you win your case, some people say, well, now does Northwestern Mutual pay me in perpetuity now that I took them to court and they won? Well, no, they can't. The court can't require Northwestern Mutual to pay you in perpetuity, as you know, in that you're going to meet the definition of disability forever, now determined by the court, because that time hasn't come to pass yet. So the only thing they could do is award you what you're owed there, and then Northwestern Mutual has to go back and reconsider if you're eligible for ongoing benefits.
Okay, so those are some of the outcomes that a person could expect. But what I want to talk about for a minute is, how do these cases usually resolve? And the way these cases usually go down after, this is assuming that you've lost an appeal and you file a lawsuit, is that there's a court-ordered required mediation. And a mediation is where the lawyer, the claimant, and the insurance company have to come to a meeting with an independent person, and it's almost like buying a car, somewhat going back and forth, making offers, and you try to get to a resolution where you leave with some kind of settlement. More often than not, it's a lump sum settlement where Northwestern Mutual says, look, we're just going to buy out your policy and we're going to have a complete settlement and divorce of each other. And the nice thing about being in that situation is that a claimant has certainty, which means if you're going to a trial, Caesar, and we have someone who's owed, $200,000 in back benefits, and then they have another 5 years left on the policy, which is going to pay them another $300,000, they know the total value of what they have in their disability contract is $500,000, right? So if Northwestern Mutual were to offer them $250,000, it then becomes a business decision for the client, because now you have a guaranteed $250,000, but you know that if you go to trial, maybe you have the opportunity to get to $500,000. Not even a guarantee with that, because as you said, like in my scenario, I just said the person's owed $200,000, right? Well, if they win the trial, the court's going to say you're awarded your $200,000, and now for the next 3 years, Northwestern Mutual is going to reevaluate your claim, and guess what? They can deny you again. And then you got to go through all of this again to try to get your money. So most of these claims, and when I say most, like 95% of these resolve in some kind of a lump sum settlement, because it's a compromise on both sides. And there's a level of certainty, and usually it's not worth rolling the dice when you have the certainty. The other thing is, Caesar, is that it could be another 18 months to 3 years from mediation to winning a trial to going through an appeal. And that time, and all of that time, unfortunately, the claimant's not getting any money.
And people need to understand that litigation and trials, and particularly, it's not, the trial takes a few days, okay? But the lead up to that trial, the litigation process, is extremely time consuming and expensive.
Yes.
On both sides.
Now, but for the claimants, the nice thing about our firm is we don't charge any fees or costs unless we're going to win that case. However, those costs, and well, not the fees, but those costs need to be reimbursed. Some states, it's becoming less and less in these private first-party breach of contract cases, will award attorney's fees. The ERISA ones, usually you will get attorney's fees if you prevail on the merits and you win. But on these individual breach of contract cases, there may not be any attorney fee award. So our contingency fee stays the same regardless, but if there's an attorney fee award, and say we had a $100,000 attorney fee award, $100,000 contingency fee that was owed to us, and the court awards $100,000 in attorney's fees, then it doesn't cost the claimant anything because we're going to take the attorney fee award, offset our contingency fee, and the client's made whole. But in many of these states, they don't have this attorney fee provision, which is unfortunate.
Right.
But with the individual disability claims, like you mentioned, there may be a bad faith, there may be a punitive damage, there may be compensatory damages. There's other options that may be available. Not common, very rare, but certainly something that we've been involved with many times and something that we're going to explore for a claimant. So, look, we scratched the surface here about what people can expect in an appeal, in a lawsuit, what the remedies are. What I highly recommend for a claimant, as we always do, is reach out to Caesar or myself. No matter where you live in the country, we're available to assist you. We'll want to review a copy of your denial letter. We'll immediately let you know if we can help you. And we always offer a free consultation. We look forward to the opportunity to speak with you.